welcome everyone. Again, my name is Kiowa Hammonds, and today we'll be talking about digitization and libraries. This is part one of a two-part series. Digitization and libraries, specifically on how U.S. copyright law offers libraries both benefits and challenges for digitization projects and access. To give a little bit of background for myself, I am the manager of rights clearance at the New York Public Library. At the library, my duties include researching rights holders within NYPL's collections. I also manage a team of digitization coordinators who are focused on project management for digitization of collection materials, and that includes copyright, research, and active licensing and clearance. Myself and my team also handle rights metadata implementation, which is used to document rights research, permissions, and required copyright notices. I advise staff on copyright-related questions and policies, draft and review contracts, rights, as well as helping with advice on copyright issues related to exhibitions and publications, among other things. So on today's agenda, we'll be talking again about digitization, what it is and what it means for libraries, how U.S. copyright law helps and restricts these projects, including exceptions in the law for libraries specifically, and determining how collections and best practices can be incorporated into a digitization project. Before I get started, I have to say that nothing you hear today should be construed as legal advice. This information is given for legal education purposes only. It may not work for your situation. If you'd like legal advice for your particular situation, I suggest you engage in legal counsel. Nothing myself as the presenter says today should be attributed to a particular client. With all that said, let's get started. So what is digitization? Digitization is defined as the process of converting information into a digital, i.e. computer readable format from an analog to digital form. To give a bit of history about digitization, the concept and the practice is over 75 years in development. Such early innovations as machine-readable punch cards developed by IBM in 1928, the development of microfilm in the 1930s, and the concept of hypertext coined by Ted Nelson in 1965 all have contributed greatly to the concept of digitalization and digital archives. Remote accessible databases were developed in the 1960s with the first online service called Dialog, released in 1972. The 1980s saw a revolution in end-user software through the development of CD-ROM. And in the 1990s, the creation of electronic thesis and dissertation databases such as Archive and CogPrint marked the first online open access repositories for e-print scholarly papers. By the end of the 90s, the idea of digital repositories grew to include digital artifacts that could be made accessible to the general public. These early databases included the California Environmental Digital Library, the Infomedia Digital Video Library, and the University of Michigan's Digital Library, among many others that lead us into the 21st century. So, with digitization in mind, let's talk about what a digital library is. And the best way to do this is with a few quotes. So, a digital library is a library that maintains all or a substantial part of its collection in computer processable form as an alternative, supplement, or complement to the conventional printed and microfilm materials that currently dominate library collections. That's a quote from William Safady. Another quote, a digital library is a machine-readable representation of materials which may be found in a university library together with organizing information intended to help users find specific information. A digital library service is an assemblage of digital computing, storage, and communicating machinery together with the software needed to reprise, emulate, and extend the services provided by conventional libraries based on paper and other material means of collecting, storing, cataloging, finding, and disseminating information. That's a quote from Edward Fox. And lastly, digital libraries are organized collections of digital information. They combine the structuring and gathering of information, which libraries and archives have always done, with the digital representation that computers have made possible. That's a quote from Michael Lesk. So the types of digitization that we'll be focusing on in both part 1 and part 2 are mainly collection digitization, which includes special collections, including manuscripts and archives, general research materials, and book scans, ebooks, e-articles and e-journals, massive open online courses or MOOCs, audio and moving image materials, and born digital materials. And just to give a side note, some of those we're going to be focusing on more in part 2. Today is very much centered on collection material digitization. Now, there are some great advantages for libraries to consider when thinking of digitization, and these include better access. The use of a digital online image and a repository has been growing steadily. Currently, DPLA has over 49 million digital assets online from over 6,000 institutions. New York Public Library has over 870,000 digitized items currently on our digital collections website. Also, preservation. Our library collections are filled with materials that are fragile or deteriorating, as we all know. A digital surrogate allows us to service these materials in ways that eliminates the risk of further damage. In some cases, the digital file allows easier reading of the text itself, particularly if deep zoom or OCR has been applied to the file. A digital copy also serves as an easier alternative to servicing research copies to our patrons. Space management. There is only so much room in our physical libraries to properly house collection materials, and growing trends to utilize offsite storage means that paging materials can be delayed. Whereas the production of new microfilm and microfiche helped to better utilize space in the past, it's becoming harder to budget and store these materials as well. Digitization offers a way to help minimize the utilization of space in our branches, opening up options for better storage of the physical materials. Also, verifiable primary and secondary resources. Online repositories of digital collections allow users ways to locate primary and secondary sources for works provenance, as well as important contextual information for users to understand the history and meaning of that work. Now, to say the benefits, I also have to speak to the challenges and disadvantages of a digitization project. Might as well get these out of the way right now. For one, digitization is costly. According to a 2020 report by the Council on Library and Information Resources, and I quote, "The average cost for digitizing a book page, including scanning, metadata creation, automated generation of OCR, and minimally encoded text, and associated activities, including identifying and preparing the materials, quality control, and project management, is about $5.32. Now that's per page. So for a brief 300-page book, this works out to about $1,600. We also need to take into account digitization equipment, such as cameras and storage, as well as possible conservation work that might be needed before that material gets in front of the camera. Also, what happens when the software or hardware used to interpret or store your digital assets becomes outdated and unavailable? So that means that continual maintenance of a library's DAM system, as well as reviews of the files stored, is necessary. That just segues into storage itself, which is, of course, essential for maintaining a digital collection. Just to give a range of that, in 2022, the Internet Archive claimed to have over 20 petabytes or 20,000 terabytes of data stored in their digital library. This includes their web pages, books, video, music, and software. And how do we make our digital assets findable and the information about them more accurate? We need metadata, which is crucial for making sense of the digital files we store and make available. And of course, there are the legal and ethical challenges of creating a digital collection and making it available for our patrons. So if you haven't been completely dissuaded and clicked off your camera, you're still here. That means you like the benefits more than the disadvantages. So let's keep going with that. So, US copyright law and digitization. So with a general idea of the benefits and challenges of digitizing a library's collection, let's talk about how copyright law plays into it. To start, we need a bit of background on what copyright is as well. According to Section 102A of U.S. copyright law, a copyright exists in any original work of authorship fixed in a tangible medium. These mediums include literary works, musical works, dramatic works, pantomimes and choreographic work, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, sound recordings, and architectural works. Some things that are not copyrightable under 102 Section B, those include ideas, procedures, processes, systems, methods of operation, concepts, principles, or discoveries. This is regardless of the form in which it's described, explained, illustrated, or embodied in such a work. So with those 2 points, we're speaking of fixation versus conceptual. There needs to be a tangible element to a creative work besides an idea floating in the ether in order for it to be copyrightable. Also, expression versus fact. If a work expresses creative characteristics beyond factual information, then it is indeed copyrightable. Copyright law exists in Article 1, Clause 8 of the Constitution, which states the purpose of copyright as a means to promote the progress of science and the useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. Physical ownership does not equal necessarily copyright ownership. Unless the copyright to a work is transferred to the owner, it is the artist that owns the intellectual property rights for their work. We must also bear in mind that the purpose of copyright is to grant and protect one's exclusive rights to their work, but with durational limits and exceptions and exceptions that are there to incentivize the creation of newer works. So what does one get with those exclusive rights? They include the right to make copies of the work, to distribute the work, to perform the work in public, to display the work in public, as well as to make derivative works based on the original work. That last one being of significant importance when considering digitization, which is currently and often viewed as a derivative of the original physical copy. So the purpose of an archive, as we know, is to collect, preserve, and make accessible collections of materials for the public. So how do we as library professionals maintain the needed balance between broadening access to collection materials and protecting the exclusive rights of the creators of that work? These exclusive rights affect library digitization in a number of ways. And I'm going to get to the answers to these questions, but we should pose them first. How can a library make a copy of a work for preservation and access? How can we distribute a digital copy to patrons or feature it online? And how can we encourage our patrons to make new creative works inspired by and to make derivatives of that original work? Now, fortunately, the limited times and exceptions within U.S. copyright law does allow some leeway in making digital surrogates and distributing them, which we're going to get into right now. When considering digitization and U.S. copyright law, we should first look as how long a work is actually protected under U.S. copyright law. Under the U.S. Copyright Act of 1976, works created after January 1st, 1978 are protected for the life of the author plus 70 years. For anonymous or pseudonymous work or work made for hire, it's 95 years from the first publication or a term of 120 years from the year of its creation, whichever expires first. Also under the 1976 Act, all works created or published on or after March 1st, 1989 no longer require a copyright notice. Copyright registration is also no longer required. So once something is taken from the ether of the mind as an idea and presented as a creative, tangible form, it is indeed copyrighted. Now, for works published before January 1st, 1978, a rights holder was required to register their work and include a proper copyright notice, which would give protections for an initial 28 years. After that 28-year term, the rights holder would need to renew their registration, which under current copyright law would give them another 67 years of protection. This means that a properly registered and renewed work that included proper notice would have 95 years of protections from the time of its initial publication and registration with the US Copyright Office. And it also, they were required to have that proper copyright symbol, which I've given an example here on the point bullet there. Now, failure to follow either formalities meant that these works fell into the public domain. Now, bear in mind that for unpublished works created before 1978, their duration of copyright protection is still, or was still, 70 years after the death of the author. So, works in the public domain are creative materials that are not protected by intellectual property laws, such as copyright, trademark, or patent laws. The public owns these works, not an individual author or artist, and anyone can use a public domain work without obtaining permission. This means that digitization and distribution of these materials are totally permissible under the law. These again include works published in the US before 1925, published before 1929, which is 95 years after registration and renewal. For unpublished works that follow copyright durations, that would be the life of the author plus 70 years for unpublished. And works created by a branch of the US federal government, which are considered to be the property of all US citizens. This includes government-produced documents and even creative works when considering the Work Progress Administration's works from the 1930s. It's important to keep in mind that federal government documents and creative works are considered the property of US citizens, but state-created documents may have individual state copyright protections. So something to consider when looking at that to see if something is in the public domain. As well, we need to consider that works that fall out of formalities within US copyright law, again, the renewal after 28 years of first publication and registration, as well as the inclusion of a proper copyright symbol. So when considering digitization, public domain works is probably the safest and best bet for works that are allowed to be digitized under US copyright law. But what about works that are identified as being in copyright? Well, there's also the transfer of copyright and licensing. Now, for these materials, like personal property, copyright can be transferred to others. Under 204A of US copyright law, a transfer through an official document such as a will or a deed of gift can transfer to a specific person or an institution like a library. The New York Public Library does own the intellectual property rights to a number of the collections that we have holdings for, such as the copyright for certain photographers, meaning that we have the copyright for those photographs. And those are definitely digitized and online. Also, it's important to at every copyright review to research the acquisition of paperwork and other documentation when you're getting a library, when you're getting a new collection in. What I mean by that is that sometimes copyright transfer or IP transfers happen at the time of the donation or the purchase of a particular collection. So it's very valuable to review any donor paperwork for the acquisition of an old or current collection. Now, licensing permission with the rights holder is another great means of getting in copyright collection material online. Many rights holders, particularly estates, have a representative like a lawyer or agency that are there to represent the licensing of their works. And the best example I can think of would be the Artists' Rights Society, which represents many visual artists and their estates. Now, there are several types of licensing that a rights holder may issue. Requirements may include licensing fees, limitations on the duration and that an image can be made available online, the limitations on the types of online uses. So sometimes they don't want it on social media, for example, or advertising, and limitations on how the image may be presented, such as restrictions on cropping or requirements for approval of a page layout or colorization before the image can go online. The New York Public Library issues non-exclusive licenses to most of our rights holders, which grants a level of use for our institution, but also allows the rights holder to grant permission to other individuals or institutions as well. The uses can be modified to be quite broad, or limited to, say, non-commercial uses. Now, when licensing for a copyright or a copyright transfer is not possible for in copyright works, U.S. copyright law does allow some exceptions specific to libraries under Section 108 of U.S. copyright law. Section 108 was enacted in 1976, offering some exceptions to libraries and archives to reproduce and distribute certain copyright works without permission on a limited basis for the purposes of preservation, replacement, or research. Now, it's through this exception that librarians and interlibrary loan services are allowed to make and distribute photocopies for patrons, and physical copies of materials can also be made to preserve them for replacement or other needs that the library has. Now, it's important to note that particular sections of 108 limit the making and distribution of digital copies, which we'll get into now. So, Section 108B, for example, allows librarians to make up to 3 copies of an unpublished work for preservation purposes or for deposit in another library or archive that is open to the public, or available to people doing specialized research. This comes with a couple caveats. The copy must currently be in the collection of the library's archives, in the library or the archives, and any copy reproduced in digital format may not be distributed outside the premises of the library or archive. So this exception allows us to make digital copies for preservation and to view them on premises, but the digital copy cannot be serviced to our patrons through a digital collection or website or email. Now, for preservation of published work, Section 108C allows an archive to make up to 3 copies of a work solely for the replacement of a copy that is damaged, deteriorating, lost, or stolen, or if the existing format in which the work is stored has become obsolete. These also have a couple caveats. The library or archive has, after a reasonable effort, determined that an unused replacement cannot be obtained at a fair price, and any copy that is reproduced in digital format cannot be made available to the public outside the premises of the library. So again, we can preserve our collections by digital means under 108B and C, but those files cannot be serviced beyond our physical walls. What are we to do? Well, fortunately, we have Section 108D and 108E to help with. These are kind of our superpowers for interlibrary loan services and for librarians making physical or digital copies of works for our patrons. So 108D provides the right of reproduction and distribution under this section applies to a copy made from the collection of a library or archives where the user makes his or her request, or from that of another library or archive, of no more than 1 article or other contribution to a copyright collection or periodical issue, under the caveats that the copy or phonorecord becomes the property of the user, and the library or archive has had no notice that the copy would be used for any purposes other than private study, scholarship, or research, and the library or archive displays prominently at the place where the orders are accepted and includes as well in its order form a warning of copyright in accordance with requirements of the Registrar for Copyrights. So note that only a small portion under 108D of a book or other materials may be copied, and it must be used for private study, scholarship, or research by the user. The request, again, needs to come through the library or another library or archive, and this applies to both published and unpublished works. One exception here for all of 108D and E is that copies may not be made of musical scores, pictorial, graphic, or sculptural work, or motion pictures or audiovisual work. That's a limitation that was put into this at the beginning We'll see if that lasts, but for now, the musical scores and exhibition catalogs are a little iffy on if they can be made under these exceptions. Now, 108E provides the right of reproduction and distribution of an entire work or a substantial part of it made from the collection or library if the user makes his or her request from that of another library or archive, and if that library or archive has first determined on the basis of a reasonable investigation that a copy of the copyrighted work cannot be obtained at a fair price. So the entire work or the substantial part of it can be copied if it is unavailable at a fair price, which is not articulated in specifics because it is somewhat interpretive as much of US law is. If it can't be found at a fair price, then we can do it. There are, again, a couple caveats, though. The copy must be the property of the user. The library or archive has no notice that the copy would be used for any other purposes than private study, scholarship, or research. And the library or archive displays, again, prominently at the place where it's accepted, a notice of copyright in accordance with the Registrar of Copyright. Now, the entire work may only be provided after reasonable investigation if it appears that the copy cannot be obtained at a fair price. Sorry, I know I said that before, but I just want to repeat it because that is an essential part that makes the difference between using a whole object, or I'm sorry, a whole book scan for research purposes or a small portion. Also, 108D applies to both published and unpublished works. Now, given that we have 108D and E, this is great for one-to-one lending of materials through a digital surrogate. But we're not there yet if we want to actually make our digitized collections more broadly available, say through a website or other digital means. For that, we have to dig a little bit deeper into US copyright law. So, fair use plays a major role in the broadening of access to library collections through digital means. Fair use is in section 107, limitations on exclusive rights. The definition in US copyright law is brief excerpts of copyright material may, under certain circumstances, be quoted verbatim for purposes such as criticism, news reporting, teaching, and research without the need for permission from or payment to a copyright holder. The determination of fair use is reliant upon four main factors, and I'll go through those briefly. The purpose and character of the use, whether the material has been used to help create something or merely copied verbatim. This is where we get the transformative use within fair use. The purpose of the material, of using the material, must be to comment upon, to criticize, or parody the original copyrighted work. The nature, this is the second factor, the nature of the copyrighted work. Is the copied work informational or entertaining in nature, say a biography or a fictional work? Is a copyrighted work published or unpublished? The scope of fair use is quite narrower to unpublished works because the author's right to control the first public appearance of his or her materials is very important. The third factor is the amount and substantiality of the portion taken. Basically, how much of the original work is taken, a sentence versus a chapter, or a 10-second clip, or a whole film. The substantiality part speaks to the contents itself. Is the chapter that you're taking speaking to a sunrise as opposed to just taking a few sentences that reveals the murderer at the end of a murder mystery? It's that the effectiveness of the amount taken and how important it is to the overall work that also plays into the amount taken. And the fourth factor is the effect of the use upon the potential market. This factor is intended to strike a balance between the benefit that the public will derive if the use is permitted and the personal gain that the copyright owner will receive if the use is denied. Now, this is not to say that just because a derivative work makes money, then it is automatically an infringement. Rather, this factor is trying to weigh the market harm the new work may cause for the original. Now, fair use has been at the center focus of two important copyright cases that have affected the course of digitization and cultural institutions, which I'm going to go into briefly now. The first case is Authors Guild Inc. v. Google Inc. Just to give a bit of a background, Google launched the Google Book Search service in 2002, which collected full book scans of public domain and in-copyrighted books from partnering libraries. These included NYPL, Stanford, Harvard, Oxford, and the University of Michigan. Using optical character recognition, or OCR, the text was incorporated into Google's search capabilities. In 2005, the Authors Guild filed a class action lawsuit against Google, claiming copyright infringement for the massive amounts of in-copyrighted works scanned without permission. Now, after a failed attempt at a settlement, the case was eventually heard in federal court for through both the Southern District of New York and the Second Circuit Court of Appeals between 2012 and 2015. So keep in mind, this project itself started in 2002, and it went to court in 2012. Now, both courts found that Google's use of the scans fell within the scope of fair use. Under the first factor, the courts ruled that Google's use was transformative, stating, and I quote, Google's making of a digital copy to provide a search function augments public knowledge by making available information about the plaintiff's books without providing the public with a substantial substitute for matter protected under that plaintiff's copyright interests in the original works or derivatives of them. So basically, that although Google made full scans of in-copyrighted works, the information derived and made available was limited to the public and utilized in a transformative way through their search engine. For the second factor, Google's transformative use provided information about the original rather than replicating the protected expression of the original work in a manner that provided a substitute, or I'm sorry, in a manner that did not provide a substitute for the original. It was fundamentally different. For the third factor, the courts agreed that although the books were scanned in full, this was indeed necessary in order to extract that information, particularly for the search engine function. And regarding the project's potential to impact the market of the original copyrighted works, the courts held that despite the search function's potential to cause some loss of sales, the cumbersome, and this is a quote, the cumbersome, disjointed, and incomplete nature of the aggregation of snippets made available through the snippet view in Google's books made it unlikely that Google's use could provide a significant substitute for the purchase of the author's book. In a way, it may encourage, because on Google Books, it has the options to purchase the book from various different online retailers. So the second case that utilized fair use and digitization that I want to speak to is Authors Guild Inc. v. HathiTrust. So the second Authors Guild case here. This was a 2014 case heard in the United States Court of Appeals for the Second Circuit. Here, the defendants comprised of a group of participating universities that utilized the shared digital repository HathiTrust, which collected the digital scans lent to Google from each of the participating university libraries for the Google Book Search project. At the time of the suit, Hathi contained copies of more than 10 million works. Now, Hathi's intention is to use the digital copies for specific things. These are to create databases for full-text searching for the general public, to permit library patrons with certified print disabilities to have access to full text of the works, and to allow libraries to replace their original copies when lost, destroyed, or stolen, and where replacement was unobtainable at a fair price elsewhere. So little light bulb there on some of the language that's being used by Hathi, and how that applies to exceptions for libraries within US copyright law. Now, similar to the Google case, the court held that the full text search was quintessentially transformative because the result of a word search is different in purpose, character, expression, meaning, and message from the page and the book from which it is drawn. This included in the court's eyes, to access to the full scans for the print disabled. The court further held that the copies were necessary to facilitate library services to the public and to mitigate the risk of disaster or data loss. Also, in the Google case, the court held that the full text scans retained were necessary and posed no harm to any existing potential markets of the copyright work, and the courts for the Hadi case upheld that same reasoning in its ruling for this case. So what is the impact of both of these cases for digitization? Well, for one, it's important to keep in mind the perception of the internet when these cases were originally filed, as well as the technological advancements since their filings. In 2005, Google was a relatively young search engine site, and the access of digital book scans through devices such as Kindles, iPads, and phones was not fully developed. Now, Google today is a powerful information conglomerate, for better or for worse, and at the time these cases were resolved by 2015, it was reported that over 120 million patrons had downloaded books from the ebook lending service Overdrive alone. So clearly, the public's need for access to digital collections had become much more increased and paramount. And we can see the needs of the public furthered by the rise of digital repositories like the Internet Archive and DPLA, which have utilized the argument of fair use held by the courts in both these cases as a means to make available materials that are not necessarily in the public domain. And at the core of these arguments is that digitization can be indeed a transformative use from their original print versions, and that access to these files did not necessarily mean a harm to the market of the original copies. And it has also greatly contributed to the justification of things like controlled digital lending, which I'm going to speak to more in part 2 of this presentation, including the Haché versus Internet Archive case. So with all we've talked about today, I'd like to conclude with some suggestions for best practices for digitization within the exceptions and limitations of US copyright law. How can libraries and museums take the plunge and embark on a digitization project when faced with the very real possibility that if a rights holder were to come forward and file suit, that an institution may be liable to up to $150,000 per infringement under Section 504(c)(2) of US copyright law. Now, there's also the Case Act, which limits statutory damages, but it's still a pretty penny for an infringement case. And how do we as scholars, researchers, and archivists also protect the integrity and IP of the creators of works within our collections? So when thinking of best practices, its first thing is to consider why we should digitize our collection materials in the first place. Considerations for digitization, and these were stated by the Library of Congress, and I'm going to quote them a little bit. What is the purpose of the digitization project? Is it for preservation, accessibility, space management, etc.? Also, who will be the users of the digital surrogates? Fundamentally, should be our patrons. How will digital surrogates be presented? Are they going to be available strictly in our buildings? Are they going to be available on websites, on databases, etc.? And what will be the effect of the original collection items if we make digital surrogates? Will the digital surrogates promote research of these collections, or will they hinder the use of the physical items? And how will the digitized files be accessed and stored? This is where we have to consider things like cost and the resources and personnel to maintain proper storage and dissemination of these digital assets. I also want to speak to the digitization principles and copyright, which was a document that the ALA made a declaration on in 2007. And I quote here, again, for best practices, access to and use of digital content that is protected by copyright should be provided in a fair and equitable manner, balancing the rights and privileges of users, creators, and owners. Also, rights management policies and procedures must promote the advancement and sharing of knowledge, innovation, and creativity. So these are important factors to think of in just the consideration of embarking on a digitization project. Second is to put the needed research into the copyright of the materials. As we discussed throughout this presentation, what is the copyright status of the items that you want to digitize? Are they in the public domain? Is the intention to give limited access to specific patrons under 108, as well as a fair use analysis under the 4 factors to consider if it's beneficial or is there too much risk in creating a digital repository that is available to the public more broadly. Also, let's not forget licensing or the transfer of copyright. There are definitely incentives to go out and seek permission from a rights holder, but it's also something that needs to be considered. Do you have the budgets for possible licensing fees and the technology to fit possible limitations that they may put on, such as time limits on how long an image may be available? A third thing to consider for best practices is open access. Now we're going to dive deeper into what open access is in part 2, but in short, open access is a set of principles and a range of practices through which research outputs are distributed online, free of access charges or other barriers. Broad access to digital materials speaks to the core mission of libraries to make our materials available to our patrons. Open access also allows and strengthens our use of the materials under fair use by ensuring that no monetary gains are benefited from making these materials available to everyone. Also, for best practices, I would suggest a copyright management information system, which can be extremely useful in helping to track the uses of copyright materials, ensure compliance with licensing agreements, and to manage renewals and expirations of rights. The Copyright Management Information System, or CMIs, was first defined under the Digital Millennium Copyright Act and is often incorporated into digital asset management systems. Also, educational initiatives and advocacy. So copyright management information also speaks to the need to educate our patrons about copyright law more broadly and to promote respect for intellectual property law that can help prevent unintentional violations. So what I mean here is that we have a responsibility for making things more accessible to also make sure that our patrons understand the full scope of why they're made available and the possible risk that they'll face with further downstream use. And finally, collaboration and partnerships. Working in partnership with other libraries, publishers, and copyright holders can lead to mutually beneficial solutions and shared best practices. There's no use in building a digital collection within a bubble. Support from other institutions that are digitizing their collections can help answer copyright questions. It can help assess risk and open possible partnerships to help your collections open up to larger audiences and users. And with that, we conclude part 1 of my discussion on digitization and copyright. I hope you will tune in next month for part 2, where we'll discuss how digital access strategies such as e-resources, web archives, and controlled digital lending affect libraries, the idea of a global digital archive, and how libraries can navigate collection strategies in the new normal of born digital archives and audio moving image materials. So thanks, everyone. Bye.